Welcome to the You Don't Know What You Don't Know podcast by Innovative Business Advisors. Successful business owners who have started, grown, and led businesses share their journey and direction for the benefit of those traveling the same path.
Well, welcome everybody to the You Don't Know What You Don't Know podcast. We are honored today to have David Weiss with us. David is a business attorney, and he's represented small and medium-sized businesses, nonprofits, and individuals for more than 30 years. And he practices in such areas as enterprise formation, governance and disputes, business succession planning, contract negotiation and enforcement, mergers and acquisitions, commercial transactions, real estate, homeowner and condo association, and estate planning. David routinely represents clients in the boardroom, and after first chairing over 60 trials, he also provides strategic guidance in litigation involving business disputes, shareholder and corporate governance matters, and homeowner and condominium disputes. Some of the people that he serves include manufacturers and distributors, marketing and ad agencies, restaurants and other B2C enterprises, architects, engineers, other medical professionals, homeowners associations, real estate ventures, national and local professional organizations, and nonprofits. David's a firm believer in giving back to the community, and it serves in a variety of capacities, including his current position on the board of trustees of his alma mater, Webster University, the Christian Hospital Foundation, and the St. Louis County Parks Foundation. He also shares his legal knowledge through seminars, broadcasts, and through his ever-popular elawlines.com website. David, welcome, and great to see you, and great to have you with us today.
Stephen, it's great to be back with you. I enjoyed talking to you all the time, so thank you.
We're excited about this. Listen, I asked you specifically if you'd come on and talk about the Corporate Transparency Act, because so few business owners really know what's going on here and understand what it's all about. And I know that you've got a good deal of information to share, and I'm really excited that you agreed to come on and share your knowledge with our audience.
I thought you wanted me back on because you couldn't get enough of it, and just it's just so much fun.
It seems to keep going on with the court cases, right?
It's a wonderful piece of legislation. It was its birth was quite convoluted. It was actually passed as part of on a January 1 of, I believe, 2021. It was 2021 as part of the defense appropriation. So that's just imagine Congress there on January 1. That's the thing you got to wrap your head around. Okay.
Yeah.
But what we're going to talk about today is something called the Corporate Transparency Act, and it is part of it's an amendment to the banking acts in the U.S. And the banking acts have been around for a long time, but they really got beefed up and taken more seriously after 9/11. And what they wanted to do is shut down the money flow for nefarious actors. Everything from terrorists, your traditional, what we think of, I guess, as Middle Eastern terrorists, to domestic terrorism, Russian oligarchs, and others that are on the bad people list, the naughty list, as Santa would call it right about now. And the idea was, most business people that have gone and opened accounts in the last certainly 10 years, if not a little longer, you go to the bank and they're going to ask, well, I need to see your ID, Stephen. I know who you are, but I still need to see your driver's license. And are you the only owner, and what percentage, and all that? That's all part of the Financial Crimes Enforcement Network. And what this act was intended to do was to push it downfield a little bit. So it's not just the bankers that are trying to catch these, bad persons, okay? But it's also allowing others that have interaction to find out, if you've got a bad actor. So you could have someone that opens up an account, but the actual owners, all right, the members, not the manager, but the members of an LLC are, two of the guys that were terrorists on 9/11, who bombed the Murrah building down in Oklahoma, those kinds of individuals, as well as Russian oligarchs. So you could have a front person, but who's the people that control the actual business itself and has the power to make those decisions, or owns 25% or more. And so they cast a pretty wide net, but having registered a good number of businesses over these last, certainly 6 to 8 months, if not a little longer, it's a relatively painless process. The first time you do it, it's kind of daunting, but then you realize, oh, okay, this is how you do it, and it moves pretty quickly. But the idea is to catch people that might be using the banking system to basically sanitize money that can then be used for other purposes that can harm the United States and its population. Now, this has been going along somewhat smoothly, as we discussed before we went on the podcast. Really haven't heard a lot about it, and that's I've heard a few PSAs, public service announcements, in the last month or so. I've heard certainly from other accountants and other attorneys. They're pushing out the information, but it's not getting down to Main Street. And I think that's going to be the real problem. How do you get this out? Well, perhaps the one thing that may have made it more more people to know about it was an injunction that was just issued on December 3rd down in Texas, of all places. Can you imagine Texas and joining the federal government on something? But that's what indeed happened. So a Texas court found that there was a likelihood or probability of success on the merits that would find the Corporate Transparency Act and its requirements under what's called the Beneficial Ownership Information Report were unconstitutional. Now, everybody says, well, then it's done. It's like, no, there's other courts that have found it was constitutional, but they didn't issue an injunction because it was the law. They didn't need to stop anything. So when this Texas court decided it was time to shut it down, they issue a nationwide injunction, and there's standards for issuing that. Excuse me. There's standards for finding if that's reasonable, because as part of our federal court system is you have these different circuits and they allow different opinions to percolate up, and you have a real exchange of ideas and perspectives. But they've shut it down because they issued a nationwide injunction. I would have thought that either the 11th Circuit, the 11th or 5th Circuit would have overturned it if the Department of Treasury wanted to pursue that. But I don't think they've appealed it. But I don't know that they've taken any extraordinary action. Perhaps it just hasn't gotten any press. And to be honest with you, at this time of the year, it is pretty busy for a corporate attorney. I'm not looking to dig through and see what's going on in the docket entries on a case that I'm not involved with. But the situation is right now everybody's got a pass, so now there's no reason that you'll have to tell your loved ones, I couldn't get you the birthday or the Christmas gift you want or Hanukkah gift or whatnot, because you don't have to worry about applying for the Beneficial Ownership Information Report under the Corporate Transparency Act. So that's where we are. All right.
Well, one thing we know for sure is it's in the courts, and this thing is not dead. It's just it is an injunction. So it's an
injunction.
Right.
Right. And an injunction is just the status quo. It just freezes the status quo. And in this case, it's the status quo immediately before they started implementing this. Now, there's been actually some one commentator who said it only applies to companies that were in existence prior to January 1 of 2024, because their deadline for filing is December 31 of 2024. If you formed a new company in 2024, you have 90 days. So if you formed a company today, you'd have until, and this is just rough, but you'd have until March 16th approximately. I'm sorry. Yes, you'd have until March 16th. If you started a company on January 2nd, you'd have until February 2nd. You only have 30 days to file. So this is all, the dates are all over the board right now, but everything's been shut down by the action of the Texas United States District Court for the Eastern District of Texas. So.
Well, listen, let me pull your slide deck up and let's go through it and let's spend some time educating people on this because it's, as you said, it's just a stay. So this is probably going to come back around, and I think there is a whole dearth of information out there. I've talked to very few business owners that are even aware of it. So I think this will be very, very helpful.
Okay, there we are, money laundering. So that's what we just talked about, that it's the dirty money, and we're trying to, what those perpetrators were doing, where they were sanitizing the money to make it clean so they could put it into the banking system. And that's what this Corporate Transparency Act is trying to do, shut down that pipeline.
Yes, sir. Very noble intent.
Very noble intent. But so how do they do this? So they start with something called defining a reporting company. And a reporting company is any company that you create by filing paperwork in a Secretary of State's office or a similar office. There in some jurisdictions other than Missouri, you might have to file with the state banking comptroller or something of that nature, or insurance commissioner of insurance. But a domestic reporting company is one that's created by filing this paperwork to make the entity. It could be the Secretary of State. That's usually, where I would think 99% of the entities are created. Or it could also be an Indian tribe. And so, if that's the case, you're a domestic reporting company. If you are a foreign reporting company, it is a similar process, but it was in some other country, whether it's Canada, Mexico, France, wherever, that you went to some office and you had to file the paperwork. Now, if you are a true partnership, which can be just a handshake or just a wink and a nod, but nothing is filed with the Secretary of State, you're not a domestic reporting company. And so that comes into play with, I'll tell you, the biggest area that I see day to day is for homeowners associations. If they never created a nonprofit, which is the general entity that's used for those subdivisions, if they didn't form a nonprofit and they're just an association, they don't have to file because they're not part of it. But if you're a condominium association, almost all of those are going to be formed by an entity. They're newer than the subdivisions are. So even a commercial homeowners association, you might have not a homeowners, but you might have an association governing a commercial property, and absolutely.
Those would also then apply into that scenario, right?
Exactly. So if you have commercial condominiums, you're going to have an association. The fact that it's commercial makes no difference. Nonprofit status won't get you out of the reporting. Okay, let's take it. Let's keep going. Who's going to be affected? This is the big thing. It's a very broad net. They said 32.5 million. I've actually seen numbers of in excess of 34 million now are affected by this, and so it's very large. There are a good number of filings that have already occurred, but nowhere near at 11 and a half months into this year, there's nowhere near 11 and a half twelfths of all these companies have filed. So there's a lot it's still in the wings. And going forward, it's going to be, they estimate 5 million new registrations each year. The good news is it's not like filing the annual registration report for corporations, where every year you have to do it, or every 2 years if you elect the biennial. It is a one and done until there's a change. And we'll get into what changes trigger that in a few minutes.
But a sole proprietorship would not be affected by this.
A sole proprietor is not affected because they never filed anything.
Yeah, it's all on their 1040, right?
It's all on their 1040, exactly.
Yeah. All right.
So a domestic reporting company is, as I said, they filed something with the Secretary of State or an Indian tribe or some comparable office, and a foreign is domestic. I'm sorry, a foreign reporting company is a business is formed under a non-U.S. jurisdiction, required to do business with the Secretary of State's office or a comparable Indian tribe. I can't think of one company in all my years of practicing that I've had. Well, I've represented foreign entities, but never an Indian tribe. All right. This will encompass not just corporations and LLCs, but also limited partnerships. Some states have limited liability, limited partnerships, and limited liability, limited corporations, and other entities. Delaware has the business trust. All right, and so there's entities that are going to be caught or subject to this law. But for those of us in Missouri and Illinois, the main emphasis is going to be on corporations and LLCs, and to some extent limited partnerships. But to be honest, I don't see many of those anymore now either. So, new ones anyway. So who's exempted? So this is the big thing. So they cast this net, and it covers all businesses, but not everybody's got a file, because some of them, it would be duplicative. What the government is trying to do, the federal government, they're trying to find out who is behind these businesses. So if you are a publicly traded company, if you are a bank or an insurance company, all of that ownership information and management information is already subjected to and through the commissioners of insurance, the Department of the Comptroller's Office, Department of Treasury, and whatnot. And so they're already getting through that. But there are a lot of other exemptions that are present, and those include the large, as I said, the large operating companies. If you're on the New York Stock Exchange or some other publicly traded exchange, you're getting pretty fully vetted there. And the fact that you might own 300 shares of whether it's General Motor or Nvidia or whoever, that's not going to really change anything. You're not going to be able to move a whole lot of money through that. At least that's what they think right now. But there's also tax exempt entities. And when I say tax exempt, let's be clear here. So you can file the paperwork to be a nonprofit corporation here in Missouri. But that doesn't make you a tax exempt entity. That just means you're nonprofit, and there's certain rules that apply to you, but it has nothing to do with the tax law or what you report on. The type of entity is governed by the state. The tax status is governed by the federal government, all right, and to some extent the state government. But generally they're in tandem, so whatever happens federally, the states will follow. There might be few different little rules here and there, but not so much in Missouri. So a tax exempt organization is an organization that has 501c status. Now, we all have heard of the C3, that's your charitable entities, but there's also quite common your 4s and your 6s. Your 4 is going to be more for your scientific organizations, agricultural and whatnot, and your 6 are for your trade associations. Comes to mind, chambers of commerce, all right? Mm-hmm. And so if you're any 501c organization, then you're exempt from it. Now, the question is, can I form an entity and you've got 20 7 months to get your exemption from the IRS. During that period, what do? Well, my recommendation is you file, because until you have that determination, I don't think I don't think you can go to bed knowing and have a good night's sleep knowing that you might not get that determination. So that's my recommendation. Shall we go? Yeah. Before we go, homeowners associations and condo associations, many of them, not all. I see a few that are LLCs or even a regular for-profit corporation. I don't know why, but that's what they are and have been for years, and it works, so I won't worry. But if you're one of these entities, you may again be a nonprofit entity, and that has certain benefits from a liability perspective here in Missouri, and other facets that may attract you to it. But it doesn't make you a 501c anything, and so you're still subject to compliance with it. And I'll talk to you a little bit later about how that impacts those organizations. So there's also inactive entities, and this happens a lot. Think of it, you or your parents or your sister or somebody they buy a rental property, and somebody says you ought to put it in a limited liability company. You do that, and you run it for 8 years, then you sell the property, and you never terminate the LLC. All right. Well, that LLC is still active, and you would have to file. Well, you may have even forgotten about it as a practical matter. So you kind of get a pass here, but you need to double check and make sure you do qualify. So it is for any entity that was in existence before January 1, 2020, which is the date that they passed the bill, by the way, not engaged in active business, not owned directly or indirectly by any foreign person, and has not experienced a change in ownership. Our center received funds in an amount equal to or greater than $1,000 in the previous 12 months, and otherwise does not hold any assets. So if you're LLC, a case in point, a family LLC, they took mom and dad's farm, 2,800 acres, and it's owned by 8 kids, and they've got this LLC for liability protection, but they don't trade any money. They each pay their 1/8 share for the taxes and for the insurance and whatnot. Does that qualify? No, because it owns an asset, and so it would have to file. So we'll go pretty quickly now. Any SEC reporting issuer, any government authority. So let's say a public-private entity like Bi-State Development Corporation, that would be exempted. Banks, credit unions, money service businesses, they're highly regulated. Insurance companies, keep going. People can read this. It's pretty easy. What's interesting is accounting firms are exempted, but attorneys aren't. Well, you can tell who had the ears of the legislators on that, okay? That's not one we take lightly, okay? I'm going to tell you that, okay?
It's surprising, huh?
Very surprise all of us on the legal side, okay? Yeah. But you can see, you can read. Everybody can read this, and see, what your exemptions are. There's 23, but I hit upon the bigger one. So what if you're not exempted? Next slide. So if you're not exempted, then you have to comply with it, and you file a beneficial ownership information report. Well, what's a beneficial owner? Well, a beneficial owner is anyone who either exercises substantial control over the entity, the reporting company, or owns or controls 25% of the ownership interest. So who is it that exercises control? Well, the president/CEO exercises that control because they can fire anybody. Now, what about the president and CEO? Can they be fired? Sure, by the board of directors. So all of those individuals are beneficial owners. There's also the CFOs. They exercise substantial control in most businesses. and there may be some others. So if they have the power to remove people or decide what's going to be purchased and whatnot, they all fall within the parameters of exercising substantial control, and they have a duty to file these reports. Also, what about the 25%? Well, if Stephen, if I have owned 25% and you have an option upon my retirement, which will never happen, but if it were to happen, you have an option to buy that 25%. Do you have are you a beneficial owner? Well, that's the question. If you have a warrant that's convertible, it is. Some of these options are. If you're just a transfer on death on a stock certificate, I don't think you are. And so it gets a little, you really have to look at it, and it's not just a quick glance and say, oh, well, I am or I am not, because there could be exceptions to the exceptions.
Well, one of the questions I've heard is LLCs, you typically select, you're either a manager or member driven, right? So a member obviously is somebody that owns the ownership of the LLC. A manager is somebody that's designated as manager. Are managers then required, or is it just the members?
No, it's also the managers, because it's much like an officer of a corporation, whether you're a president, CEO, CFO, that you would you have the ability to affect the outcome, because in the case of an LLC, the members have designated the manager to run the company.
Yeah.
So that's why it's inclusive. So the ownership, the 25% ownership requirement, is of course any present equitable interest, whether it's stock, a membership interest, or some other instrument. A promissory note that's convertible into stock would be it. Any capital or profit interest, and those are created, if you've heard of shadow stock. All right,
yeah, so right. That or phantom
you
shares.
Don't,
Phantom shares is
phantom shares.
Yeah.
So if you're basically are stair stepping with those that own the stock, then you're going to be subject to it. Now you got to have more than 25%. And the question is, how do you compute the 25? Does your phantom shares dilute everybody else's? So if you have 4 shareholders that each own 25, but you got your somebody else that is an advisor and they get 25% of phantom stock. So if you include that, now they're all at 20%. So how do you do that? I don't know that we've got, following the, frequently asked questions. I haven't seen that answer. So I always think the safest thing to do is to file, because many times it's not going to make a difference, because there's perhaps other companies where you're already disclosing that information on your behalf. There's convertible instruments, any put, call, straddle, or other option or privileges, or any other type of contract or agreement. It could be a buy-sell agreement where an employee, on a single member entity, whether it's an LLC or a corporation, they may have an agreement with their key employee that if something happens to the owner, then that person steps in and takes over the company. Well, that's a situation where I think you have to report. So, the direct or indirect ownership would include undivided interests or ownership through another individual, but not in the case of minors. So if mom and dad own an interest on a minor, that doesn't create that situation. And if there's any intermediary entities, now obviously, or maybe not so obviously, but you're not going to see a lot of that with a subchapter S corporation, because it has to be an individual that's owning it, or if you're a qualified subchapter S entity. Exempt are going to be, from the definition of beneficial owner, is minor children, a nominee or intermediary, an employee, or an individual holding a future interest. There are situations where there are qualified plans, and you could be, by virtue of that, you could hold a position that is exempted as well. So, company applicants. So the company applicant, right now, if you are an existing company as of 1/1/2024, you didn't need to fill this out. But for any new companies created on or after 1/1/24, the company applicant, and there can only be two, which I find kind of, constraining, but I'm thankful so it's not broader, but it does create a confusion. Who are they? So it's the person that actually does the filing. So let's talk about that. So a client of mine calls me and says, I want to form I'm buying a new piece of property. I want an LLC. So I talk to my paralegal and I say, this is what, or let's say I talk to my associate. I say, we need this. They go and they talk to the paralegal who actually files it. Who is the company applicant? The person who told me that they want a new entity to hold this real estate. Is it me? Is it my associate? Or is it the paralegal? Well, I think where I fall is it's the paralegal, and it's me. All right. Now, some other attorneys are saying no, it's the person who directed it at the entity level, and I'm fine with that. But I always think, I should be on it. I'm not going to let a paralegal be hanging out there without me behind them. Okay. Mm-hmm. But it's the person who directly files the document. And one way around that is you just make sure the paralegal puts my name on it for returning it versus their name. All right. And here you see in the second bullet, the attorney at a law firm or partner in an accounting firm or other individual forming an entity to hold real estate that orders or directs the formation of a new corporation or LLC. So, okay. So, it may also refer to the individual who are responsible for forming. Again, that's what I consider the person who goes ahead and calls me and says, we need the new entity. And I, there's so much written about it, but they limit it to two. You can't even put in a third person. I tried it just as a test and I won't take it. So that's my last bullet. There's on this topic. There's one or two individuals will fall into the definition: senior official directing, and the individual actually making the filing. Again, I'm going to take the hit if there is one, as being the person who filed. So next, what do you have to do? What must you do? So there's actually there's two categories, general categories of information. It is you need to identify the reporting company. So they're going to ask, where is your office? You can't use a P.O. box. You have to use a physical address. They don't care if it's your home. They just don't want boxes are us kind of a situation. They want to know if they have to go and knock on your door, they want to be knocking on a door, not a mailbox. And then the individuals who exercise that control are own 25% or more of the company. So there's two parts to it: identifying the company, and they want things like what's your state of organization or incorporation, what's your unique identifier number through the state, that kind of basic information. And they're going to ask the same thing about the beneficial owners. All right. So, and here it's just what I said: full name of the reporting company, any DBAs, any trade names, any fictitious names, what state, were you incorporated, and they also want your IRS number, which is either a taxpayer identification number or a federal employer identification number. And there's special rules if you don't have either. But next, please. The company applicant is as I said, the applicant is the person or persons who direct or actually perform the incorporation or organization. And so their names, date of birth, and street address, which can be the business address, but if none, then their residential address, and something to uniquely identify them. Again, when we're talking about that, it's generally going to be a driver's license or a passport, but I guess there's nothing to prevent you from using your Department of Corrections photo ID if you're operating an enterprise from prison, okay? I don't know how you do it, but it's pretty open. You can also use a military ID, whatever, okay? Just a photo. It cannot be expired. It's got to identify your name. So the beneficial owner, very similar, full legal name, date of birth, your current business address, or if you don't have one, your residential address, and a unique identifying number, a passport, unexpired passport, driver's license, or some other government issued ID. So the filing dates, and these are all out of whack now because of the injunction which was issued, but absent the injunction, new entities that are formed in 2024 have 90 days to complete their filing requirement. For existing entities, in other words, those existing prior to January 1 of 24, you have until the end of this year to file. And after the end of this year, after December 31 of 24, you have 30 days to file. Now, the issue becomes, and we talked about this, that there is no, it's a one and done unless there's a change, or if there's a correction that has to be made. So if you have a driver's license here in Missouri, you decide, I'm going to move to Illinois, you're going to need to file a new, an amendment to your beneficial ownership information report. I don't believe the license numbers change, certainly in Missouri. So if my number ends in 12340, and I renew my license and it's the same address and it's the same number, the fact that I got a new license is irrelevant. But if I were to move to a different address, if I got a different ID, and certainly with a passport, I think those numbers change every time you renew the passport. I haven't looked, but I do think the passport numbers change if memory serves me right. And so you have 30 days to file that information. If you notice an error, you have 30 days from the date the error is found. Now, I don't know how they know what date you found the error, but it's 30 days, and your compliance is your compliance issue. All right?
So, David, if you sell a business, which obviously is our ball of wax, right? And you're the seller, it sounds to me like there's a responsibility on the seller to file a change notice and on the buyer to file if there's a new entity, or even if they assume responsibility for an existing entity. The buyer would also have a responsibility. Can you explain that for us as you see it?
Yeah, and there's multiple aspects to that. So most companies, when you sell, are not selling the stock. They are selling
typically selling the assets, right? Yeah.
Okay, so whether they have an existing company and they're acquiring these assets, or they form a new entity to take basically an operating entity standalone and put all those assets in there. If it's the latter, they create a new entity, then the buyer would have to file these new forms, and the seller would not have to do anything. But what happens, regularly we have, so let's say the name of the company is USA Retrofitting, and the buyer's going to, or let's say it's Weiss's Retrofitting, and they're going to take it over, and they want Weiss Retrofitting as the name because it's got great, reputation. So so I will change the name of my company to something like, uh, you know, Old Weiss Retrofitting or Old Weiss's company,
Mhm.
and they'll form a new entity under some other name and a trade name of Weiss Retrofitting. All right. So there's still two separate companies, but I would have to change my registration because I have a new trade name, or I
Mhm.
change the name of my entity. And so you would have to go that way. But if you're acquiring assets, let's say you got somebody's going out of business, there's an auction, and you're buying all the kitchen equipment to add to your expanded restaurant empire, you don't need to do anything. There's
Right.
nothing there. You're just buying assets. But if the entity is sold, um, the actual stock, and we have situations where that still occurs. There's
Yep.
obviously more risk with that, but sometimes you need to do it because that's what you want, not the risk, but the benefits that came with it. And so you take that on, and you're um, you take that on, and you do have to file an updated report. Now, what do you do in your documentation? You put a requirement that it be filed and that a copy be sent to you. The problem is the confirmation copies that Financial Crimes Enforcement Network, the entity that you actually file with, is indescript. I mean, it doesn't even say, it says, you, congratulations, you have filed. They're like, it
Hmm.
doesn't say the name of the company. You don't know who it is. It
Oh my
drives me
goodness.
nuts. I can't send a confirmation to a client other than we did it, but this is all it says. It doesn't say the name of the company or who the beneficial owners were. So it is what it is. So um, it's a pretty stiff penalties. All right. It's a
Mhm.
federal crime. Uh, Failure to file or to file false reports. If you do that, um, they're going to come after you. If you go to the next page, it'll tell you, uh, what it is. Well, there's both civil and criminal. So from a civil penalty, it's not more than $500 a day. Thank God they're so lenient. Okay, that the violation continues, and maybe fined not more than $10,000, or imprisoned for not more than 2 days. That's 2 years. I'm sorry, um, and uh, and so it's a pretty major hit. Now, I can't believe that if somebody misses a report, let's say, you're uh, other than the fact that I'm a practicing lawyer, let's say I've been retired for 8 years and I never heard of this act, and I didn't file from an LLC that I have a neighboring piece of property that I rent. All right, I don't think I'm going to get 2 years in a slammer, um, but somebody's going to get picked up on this once that injunction is lifted, and you're going to have a real compliance issue. I don't
Yeah,
think
there'll be some test cases out there, won't there? Always
there will
are.
be some. Yeah, I mean, if I tried it, they'd be looking at this and saying, "You knew about it. You are going to get the $500 to pay." All right. So I think there's one more page, which is
Yep.
just a thank you. All right. And do you have any more questions, Stephen?
I do. I do. So, we talked, you touched on this earlier, and I want to reemphasize it. If you're a new entity and you're opening a bank account, um, you know, I recently went through that, not in 2024, but in 2023, and it's a lot of information that's required. Is it is it pretty much the same information, David, that FinCEN requires? I know you have experience actually filing these. I don't.
Right. Um, it's pretty much the same information. The difference is you are filing. This is broader because you go to the bank and you
Hmm.
file as a representative for the company.
Right.
They don't require that the president and CEO come. You could be the office manager and go and open that account, I believe. But with the Corporate Transparency Act, the disclosure of all of those who are beneficial owners, and remember, the definition is not only those that own 25% or more of the interest in the company, including those attenuated items like, ghost stock,
Right.
uh, you know, any of the options, puts, calls,
Puts, calls. Yeah.
whatnot, but also those that exercise control. The board of directors or the board of managers in the case of an LLC, our recommendation is each of those have to be identified. And so it becomes a bit of an issue. Um, Let me go back to the nonprofit world, and especially the HOAs, homeowners or condominium associations, where there's regular change. What do you do in that situation? Now, if you're a 501c3, you're a charitable, let's say you're the St. Louis Art Museum, that's 501c3. They're exempt from filing. They don't have to worry. But if you're a homeowners association and every year you're electing a new director, or maybe it's every 2 years that somebody, actually resigns and the position is open, you have to update that and show who is the new director. Now, what do you do with the old director? What do you do with the person that owned the 25%? There's not a lot of guidance. There's nothing that says remove them. So I think the best thing to do is to file basically an amendment for the company, and you identify as of this day, these are the 3 or 4 or 18 directors, all right, or beneficial owners. And so you update it. But then it's a problem because you got to ask everybody again. I need a copy of your passport or a copy of your license. And you know how much you love to share that over the internet with people. You don't, all right? And so what do? So FinCEN actually has something called a unique FinCEN identifier. And I went and got that done because I knew I was going to be throwing my information out there regularly. And I tell clients, I mean,
Yes,
if you've got this, so whoever owns a group of companies, and you've got a holding company and then tiers with multiple tiers below those, upper tiers, what do? Well, you don't want to be uploading your passport and your driver's license for each of these. First of all, just the time it takes, whether you're doing it or you're paying an accountant or an attorney to do it, you don't want to spend the time. So you file once and you just ask for a unique identifier number. I have one. It's a 12-digit number. I write it down and I've got it. And so until my information changes, the same with you, Steve, when your information changes, you change it there once and it goes across all of these companies. And so you don't have to worry about, I've got, 40 companies, and that's not unbelievable. If you have, if you have an operating company and they're in multiple locations in multiple states and they own the real estate under it, and they have, they put their rolling stock for that state in one company, and they put equipment in another entity, and you start having 5 and 6 entities for every state location, and you got 6 states, you got 36 entities. You don't want to be changing this for all the time, because first of all, you're going to miss one possibly, and the time it takes. So just get that unique FinCEN identifier, and you plug that number in, and you're done. So.
David, do you feel like this is something that entity owners can do on their own, or do you feel like they're well advised to have professional help?
I mean, it really depends upon who it is. I have some people that I don't think they could handle it. I know others. It's not a problem, especially if they have a CFO who's got the time. But a lot of my company owners, they're moving on to the next deal. Okay, they don't have the time to sit and, did I do this one or didn't I do this one? Let somebody that knows how to do it. It's not overly complicated. You're putting in the name of the company, if you're an LLC, you get this number that starts with an L. If you're a nonprofit, it starts with an N, and you put down the number, hopefully in the right order. I think it actually bounces back if you put in the digits in the wrong order. So they must have already downloaded all that information. But it's a pretty fast maneuver to put this information in, and it doesn't take long. So I think you could do it, but you may have questions. What if you have options? All right, or what if husband and wife? What if it's husband and wife that own the stock? What do you do there? So, do they each have it? So you're going to need some questions answered, and you can answer. Call us, call your attorney, and you can get the guidance on that. But it's after that, then In other words, we can teach you how to fish, because this is not how we make our lives better. Okay, we're just trying to help clients. We do all sorts of compliance issue. We do all sorts of compliance issues. We're not getting rich off of doing these reports. Trust me. But it does take time. That's the issue.
And this is a electronic filing. You're not compiling a packet of documents and putting them in an envelope and dropping them in the mail, right?
Correct. It's electronic. I think they have a PDF option. I've never done it because, to be honest, going to their portal and putting in the information, especially if you get your personal unique identifier number, and it's not just attorneys that can do it. Steve, if you own this conglomerate, and I don't want to divulge that you do, but all these companies, you get that one number and you drop it in, and you're done. It takes, put in the name of the new company, its identifier number, state of incorporation, physical address. If you're the applicant for the company, you put in your name and your identifier number. If you're the owner and the only, manager, you put in your name and your unique identifier, and you're done. You don't need to put in your address or anything else.
Is there any cost to register? Is it
no? It's free.
Is there any payment? There's no cost to it.
It's free. No cost.
And do you? We talked about you've got to make a filing if there's any changes. Are there any other requirements to do so on a regular, recurring basis in the future? Or once you do it, it's done unless something changes. And then
unless it changes, ours incorrect.
Okay,
that's it.
Awesome. Well, listen.
But again, there's a stay in place. So the Financial Crimes Enforcement Network, euphemistically referred to as FinCEN, has said on their website that you do not have to comply until the court case is decided, or there's been some decision even on just the temporary stay, but there's nothing to prevent you from filing. So, if you want to do it and just get it done, and the idea that you're not really being invaded by government by doing so, you can go ahead and do it. But if you're wary of that, then you don't need to do it. The key is just to know when that stay is lifted, and that's the question. If you haven't heard about this before, how are you going to hear about the stay being lifted?
Yeah, I think that's a key point. And FinCEN, I don't even know this, but is that their data is not public, so you're not going to be able to go to some website like, for example, I know one of the unintended consequences of PPP is you ended up with this public database of which entity got how much money, over what period of time, and a lot of people were quite upset that information became public.
Right. Now this is private. In fact, if you're a law enforcement agency, you can submit a court request to get access, but you have to prove it up. It's not, I'm from the Hillsborough Police Department, I need to check something out. You don't get it just with a call or a text or an email. You'd actually have to show reason for it, and it can't be shared, it can't be published. So it's very limited, and that's the way it should be, because there's personal information
here. Yeah, absolutely. Well, listen, David, we're in your debt. Thank you so much for giving us the hour and giving us the information. This is so helpful. we're going to share it with our audience, which includes a lot of private business owners here in the marketplace, and post it up on our site. And we've got your contact information here. I've left it on the screen purposely for a long period of time. People have questions or need help. We highly recommend that they get in contact with you. You're an outstanding business attorney with an impeccable reputation here in St. Louis, and a heart and drive to help business owners. So just honored that you would come on and give us this time.
Right. Steve, it was my pleasure. Best wishes for the upcoming holidays.
Thank you. Same to you and your family, David, and go out and make it a great day. And once again, thank you very much for your time. Appreciate it.
Thank you. Thank you.
All righty. Take care.
Thank you for listening to the You Don't Know What You Don't Know podcast. We invite you to visit www.youdon'tknowwhatyoudon'tknow.com and sign up to receive updates on upcoming episodes. You can also let us know if you'd like to be a guest or recommend a business owner to be interviewed. Find us on LinkedIn, Facebook, and YouTube, where you can like, follow, share, and join our efforts. Thanks for listening. We hope you join us again.